thank you to Pall Medical for inviting me to present, and good morning or good afternoon to everyone, depending upon where you're located. This is going to be a very different type of Legionella presentation than you typically heard probably in the past. As being a lawyer, I'm going to focus strictly on legal and insurance issues as they pertain to Legionella claims, as well as insurance risk for Legionnaire's disease. The presentation really assumes that you already have a pretty good understanding and background for Legionella. It's not going to be one of those presentations where I go over some of the stuff that you've probably heard 15 times before. So that's probably a good thing for you. Objectives, we're going to be first looking at the legal basis for liability in the event of a Legionnaire's disease outbreak and the elements necessary to bring what we call in law a valid tort claim. We're also going to examine what's necessary to prove liability and the precautions that must be taken to mitigate that risk and liability. We'll then examine obtaining insurance coverage for this issue, including what some of the insurance underwriters may require for you to obtain that coverage and what the coverage will typically include. So liability for Legionella is based upon the duty of a building owner to keep invitees safe when they invite them onto the premises and to protect them from foreseeable risk of injury. When we talk about what's foreseeable, it's important to understand that constructive knowledge can be implied to the building owner or operator, especially if a condition has existed for some time and would have been reasonably discovered. So that's kind of an interesting concept. So, for example, if your building water system's been operating for some time with things like insufficient chlorine levels or inadequate hot water temperatures, which are creating conditions conducive to the growth of pathogens, this can create liability under a failure to maintain. And building owners can be deemed to have constructive knowledge of this, even if you don't have actual knowledge of it. Building owners also have a duty to warn of hidden perils, and Legionella would be a hidden peril, and the failure to protect an invitee from reasonably foreseeable harm can be considered negligence and a breach of the standard of care. There may be different standards applied to different building owners based upon occupant susceptibility to Legionella, and I notice there are a lot of healthcare people on this call, and healthcare, unfortunately, you're going to be held to the highest standards of care, as you typically are. Just some basics about law. In law, when we talk about the standard of care, it's defined as the caution that a reasonable person in similar circumstances would exercise in providing care. It doesn't mean that you have to be perfect or you have to be right every time. You can be wrong, you can make mistakes, but you just can't be negligent. And in order for there to be negligence, the elements of a valid claim for negligence include a duty to exercise reasonable care, which, as I mentioned before, all building owners and managers will have to protect the invitees, a breach of that duty, such as a failure to maintain a water system, and then you need some physical harm caused by that conduct, such as Legionnaire's disease, and then you've got damages sustained as a result of the breach. And those damages can be things like medical expenses, pain and suffering, and a variety of others. So this may be the most important slide in the whole presentation. To have a valid tort claim for negligence caused by the presence of Legionella, you need 7 elements. You need to have the right bug at the right level, affecting the right plaintiff at defendant's premises from a source with the right intensity, which results in disease within the latency period. And we're going to go over all of that because it's really a mouthful. But in addition to tort claims for Legionella, there can also be claims based upon contractual liability. And that can involve things like breach of express and implied warranties, and generally applies to people like manufacturers, contractors, and product defects. An example of this would be the Legionnaire's disease outbreak that occurred years ago on the celebrity cruise ship Horizon, which resulted from a breach of warranty or faulty installation from a Pentair filter in a hot tub which sickened 16 people. And the initial judgment on that was $200 million. It was subsequently reduced on appeal, but still a considerable amount of money.